Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast. I'm your host, Spencer Karen. On October 6, 2020, the Supreme Court heard oral arguments for Rutledge v. Pharmaceutical Care Management Association. The issue in this case is whether states have the right to regulate pharmacy benefit managers, or PBMs for short. Leslie Rutledge, Arkansas's Attorney General, has petitioned the court to overturn the U.S. Court of Appeals for the 8th District's prior decision to maintain Arkansas statute regulating PBM's drug reimbursement rates. Rutledge argues the statute is preempted by the Employee Retirement Income Security Act of 1974. Max Schulman joins us to discuss this case's oral arguments. Schulman is an associate in the Washington, D.C. office of Gibson, Dunn Crutcher.
This case presents the question whether an Arkansas state law regulating prescription drug benefits is preempted by the Federal Employee Retirement Income Security Act, also known as ERISA. ERISA is a comprehensive federal statute governing employee benefit plans, such as pensions and health care plans. ERISA imposes a variety of substantive and procedural rules that apply to these plans nationwide. It also includes a broad preemption clause that prevents the states from passing laws in the same area. ERISA Section 514A, codified at 29 U.S.C. Section 1144A, expressly preempts any and all state laws that, quote, relate to, end quote, benefit plans governed by the federal statute. The key statutory text here is relate to, and the question is, what does it mean for a state law to relate to ERISA benefit plans? It's clear this clause imposes a very broad sweep of preemption. Congress passed ERISA to establish a uniform nationwide regulatory regime, and Section 514A serves that goal by avoiding a hodgepodge of state laws that would raise the costs of plan administration, which are costs ultimately passed on to the plan's beneficiaries and participants. But beyond those general principles, the statute is not very specific as to what this preemption clause covers or does not cover. Justice Scalia, despite being a textualist, wrote that simply applying this clause, according to its text, was, quote, a project doomed to failure, since, as many a curbstone philosopher has observed, everything is related to everything else, end quote. In other words, relate to is vague and unclear text, and it's unreasonable to think that Congress preempted every state law that has any conceivable effect on or relation to ERISA plans, no matter how indirect, which could include a vast proportion of what state laws do. But the text does not offer much of a principle to draw the line between what is preempted and what is not. How much of and what kind of a relation counts? So, the Supreme Court has decided many ERISA preemption cases over the years since ERISA was enacted in 1974, trying to give meaning to the words relate to in application based on the structure and purposes of ERISA. And this is an area of the law where the Supreme Court often relies on a kind of common law reasoning from those precedents, even though this is an issue of statutory interpretation, and people may think of the modern Supreme Court as typically focusing on the text. Justice Kagan said a few years ago that we are all textualists now, but at least for ERISA preemption, that's not entirely accurate. This term's case, Rutledge, is important for a few reasons. First, it's the Supreme Court's first ERISA preemption case in 5 terms since 2016. The court's last decision, Gobey v. Liberty Mutual Insurance Company, was a strong ruling in favor of broad ERISA preemption, authored by retired Justice Kennedy, writing on behalf of 6 justices. So Rutledge will be the first opportunity to see Justices Gorsuch and Kavanaugh weigh in on ERISA preemption and to learn whether they are inclined to agree with their former boss, Justice Kennedy, on this issue. Their votes in this case could give us important clues on where ERISA preemption is headed in the years to come. We could also learn more about their views of preemption doctrine more generally especially because there are other federal statutes with preemption clauses that use the same relate to language as ERISA. For example, the Federal Aviation Administration Authorization Act and the Airline Deregulation Act, respectively, preempt state laws relating to certain aspects of interstate trucking and air travel. Note, however, that this case was argued before Justice Barrett joined the court, so she will presumably not be participating in this decision, and we will have to await another case to learn her views. ERISA preemption doctrine is important because it affects a lot of people. More than 178 million Americans, or 55% of the U.S. population, receive health insurance through employment-based benefit plans, and the laws governing those plans can have very significant effects on those people's lives. This specific case is also particularly important because it will affect an important business sector that many states are currently seeking to regulate. Pharmacy benefit managers, or PBMs, are third parties that benefit plan sponsors hire to administer prescription drug benefits, including by negotiating the prices that pharmacies are reimbursed for the drugs that they dispense to plan beneficiaries and participants. PBMs are used by about 2/3 of all large employers in the United States, and 95% of all retail pharmacies do business with at least one PBM. So this is a nationwide business that involves the administration of prescription drug benefits for a large number of Americans. Arkansas and approximately 40 other states have passed laws that seek to regulate PBMs in various ways. These laws vary in their particulars, as you might expect. Arkansas's law seeks to regulate PBMs in a few ways that are relevant here. Broadly speaking, first, it imposes particular procedural rules that PBMs have to follow when negotiating drug prices with pharmacies. And second, it also imposes substantive rules on that process, including allowing pharmacies to refuse to dispense a drug if the reimbursement price falls below a certain level. So even if a benefit plan has different rules for what drugs it covers and how much it will pay for those drugs, and even if the PBM acting on the plan's behalf has negotiated with a pharmacy to follow those rules, Arkansas state law would supersede the terms of the plan on drug pricing. Our case began when the Pharmaceutical Care Management Association, PCMA, which is the National Trade Association of PBMs, sued the Attorney General of Arkansas, Leslie Rutledge, seeking to enjoin this state law on the ground that it was preempted by ERISA Section 514A. The preemption argument here boils down to a dispute about which of two Supreme Court precedents this case is more like. PCMA argues that this case is like Gobey, the court's most recent ERISA preemption case from 2016. In Gobey, the Supreme Court held that ERISA preempted a state law imposing record-keeping and disclosure requirements on benefit plans and their third-party administrators, because record-keeping and disclosure are central aspects of plan administration under ERISA, and so that state law related to those plans. PCMA argues that this case is essentially the same because the choice of what prescription drug benefits to cover and how much to pay for them is also a central aspect of plan administration that Arkansas's law has an impermissible relation to. But Arkansas argues that this case is more like a 1995 Supreme Court decision called New York State Conference of Blue Cross and Blue Shield Plans versus Travelers Insurance Company. In that case, the court held that ERISA does not preempt a state law that regulated the rates that hospitals can charge to patients, but did not impose any requirements on the benefit plan. In essence, Arkansas says its law similarly governs only PBM administration, not plan administration. In this case, the Eighth Circuit agreed with PCMA and held that the Arkansas law is preempted. Arkansas petitioned for certiorari, arguing that this decision was wrong and contrary to the decisions of other courts addressing other state laws regulating PBMs. The Supreme Court agreed to hear the case. On October 6th, the Supreme Court heard oral argument. I think we heard some mixed signals from the justices at argument. On the one hand, several justices asked questions that showed some sympathy to PCMA's framing of the case. For example, Justice Gorsuch asked counsel for Arkansas, if record-keeping in Gobey relates to health plans, then why doesn't payment for drugs here also constitute a central plan function that would fall under the preemption clause? But there were also some tough questions for PCMA's counsel, and several justices appeared wary of the fact that the PBM drug pricing business is so complicated. For example, the Chief Justice asked whether the court should look at the underlying reality of what the states are trying to regulate rather than the mechanics of how they achieve that goal, which arguably echoes some arguments made in Arkansas's brief. So I think it's possible that the court decides this case on relatively narrow grounds and tries to avoid making broad pronouncements that could destabilize ERISA preemption doctrine in an area that the justices are aware is very complex and consequential. One thing I will predict is that the court will not decide this case solely on the ground that Arkansas's law directly imposes requirements on PBMs, which are third parties, instead of on plans themselves. That's a distinction that was noted in the briefs of the United States, which participated as an amicus supporting Arkansas. But the government was asked point blank about that distinction at oral argument and essentially conceded that it is not dispositive because the preemption analysis focuses on what activity is being regulated, not on who is a specific target of the regulation. So that, I think, will not be the deciding factor here, and the court's opinion may clarify that point to help give lower courts guidance. We also heard some interesting questions at oral argument about the state of ERISA preemption doctrine generally. Justice Alito, in particular, repeatedly questioned the court's precedents, focusing on ERISA's purposes as the touchstone of preemption, and asked whether the jurisprudence should be reformulated to follow ordinary field preemption principles, which is something that the late Justices Scalia and Ginsburg once suggested. Justice Breyer asked a similar question, and Justice Kavanaugh also asked whether something's gone awry here in the jurisprudence. These questions may show some justices are dissatisfied with the current doctrinal framework for ERISA preemption. The question whether to change or abandon that framework is not squarely presented in this case, so it's unlikely the court will rule on that ground. But we may see one or more separate opinions inviting consideration of these issues in an appropriate case, and in any event, litigants would be wise to keep these questions in mind for the future.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.